Hi, I'm Matt Dana, managing partner of Dana Whitey Law, here with Associate Attorney Mr. Michael Rich. Michael, nice to have you.
Good to be here.
I understand you're a new father.
I am. Brand new baby.
Wow, so you got a whole different perspective of estate planning now than you did a couple months ago, right?
Definitely, yeah.
You know, that's one question we'll talk about right out of the gate. At what point in time should people really get serious about putting together a trust?
Well, I think big times when people get serious about putting together a trust is one, just like you said, when they start having children. All right, we want to make sure we have an estate plan that's going to pass their assets down to their beneficiaries the way they want to do it. I also think another big time is if they get married, or if neither of those happen for you and when you start acquiring a good amount of assets of your own, you still want to make sure you can designate where those assets are going to go upon your passing.
Yeah, and you know, when you start having children, you start worrying about, you know, when I die, is my wife still alive? Do I have enough life insurance? Do I have enough assets to take care of her? I think at this core estate planning level, you know, talking about the benefits of a trust, I think one of the benefits we always talk about is that if you could put some life insurance in there in your house and other assets in there, but you can provide some bumper guards and protections for your wife and bumper guards and protections for the kids. What's kind of been your experience as far as, let's you know, I had Hallie in here a little bit earlier and we talked quite a bit about, you know, one spouse dies and one spouse is alive. So with you, I want to spend a little bit more time talking about, you know, both spouses are gone and what type of proper planning can you do with core estate planning?
Yeah, well, there's a lot of different options you can do for your kids. You know, for simpler estates, sometimes we're just looking for outright distributions, but making sure the kids are of appropriate ages, they can handle the distributions, whether that's 21, 25, 30, 35.
What's the kind of the most common age you see there where somebody just says, I'll die and just give it straight to the kids and be done with it?
You know, the 25, 30, 35, I think is the most common.
Stagger it, maybe a third at 25, a third at 30, third at 35.
Yeah, exactly.
And in between there, you'd have some type of an independent trustee that would oversee it and protect it. And certainly if they needed more money kind of in between that for health, education, support, maintenance, those kinds of things, a trustee could always pay out more, but the trustee would be obligated to make these what we call outright distributions at these certain ages. At what point would you consider maybe not making outright distributions at all and maybe having assets remain in trust for the benefit of that child for their entire lifetime? What type of planning could that look like?
Well, I think if the share of any beneficiary is going to be greater than $1 million, for sure, we want to put it inside of a special subtrust that's going to protect it from creditors for the remainder of their lifetime. And we have a lot of flexibility in how we design that trust. We can make it very flexible. We can make it, you know, a little bit more restrictive when they're younger and give them more flexibility as they're older. We custom design them to each beneficiary so that they fit their specific needs.
You used the term subtrust. What does that mean? I'm not familiar with that.
Well, a subtrust is what lives inside of your revocable trust. So it doesn't exist while you're alive. It only comes into existence when you or both you and your spouse have passed away. Then we breathe life into that trust, and then it comes into an existence. We fund it with the assets that were inside of your revocable trust.
Yeah, and then with that subtrust, I can have these bumper guards we're talking about. I can have a professional trustee kind of oversee the money, maybe at different ages, rather than the kid getting a third, and a third as outright gifts. Maybe at 25, they get all of the income of the trust, and maybe at age 30, they can have a withdrawal right and take out 5% of the principal, and maybe at 35, we let them become the trustee, or maybe 35 and 2 years of training wheels with a professional trustee. These are types of things you can build into a trust, right?
Absolutely.
Yeah, and Michael, you know as well as I do that you know, we've talked a lot about why, you know, what's the number one reason why people should get a trust, and you've heard me say what the public perceives as the number one reason is probably different what we perceive. But what would you tell people? What do you think the public perceives as the number one reason why they should get a trust?
Well, number one reason, hands down, is to avoid probate. That's what everyone sees online.
Yeah, the evils of probate. Horrible probate attorneys. Takes forever. Horribly expensive. In reality, yeah, probate can be avoided, but in reality, probate isn't as big of a deal as people make it out. I think there's certainly cases in probate that take years and are complicated, but that's usually because the family's fighting the dynamics, and there's a lot of people contesting this or contesting that, or trying to throw out a trustee or trying to do something. But I just, I think our law practice has the philosophy that avoiding probate's critical, but, we probably wouldn't recommend a trust for somebody that's got just a few $100,000, a car and an IRA and stuff like that. In my mind, they probably should be up there in that $1 million range with their house and maybe some bank accounts and life insurance, right? I mean, life insurance, I'm sure you're thinking a lot about that and maybe thought a lot about that. That becomes more important. And I think if a guy's carrying $1 million or $2 million of life insurance, that's where a sub-trust for the kid could really be beneficial, right?
Right.
What would you say, in your opinion, is the number one reason why people should have a trust?
Well, I think number one reason is being able to, like we've talked about already, put in those bumper guards and safeguards for how do your kids or your beneficiaries receive that inheritance after you're gone. Although maybe the most common is that outright distribution, 25, 30, 35, it doesn't protect it for them for their lifetime. So if we have a trust and we can put in those protections and we can really kind of, grind down on making sure they use those funds in a way that's proper for them when they're younger, and then give them more control when they're older.
And I think you already kind of alluded to this. The size of the inheritance kind of makes a difference, right? I think in our mind, maybe, I think the size of the estate and the age of the kids are the factor here. And let's say the kids are all over age 35, and let's say their share of the inheritance is going to be, $1 million, $750,000. Maybe having a sub-trust is a discussion, but certainly if their inheritance is going to be over $1 million, I think, in my mind, it's worth having those bumper guards. And I would also say if they're probably below $750,000, $500,000 is their inheritance, I'd probably go with the outright stuff. I probably wouldn't impose those bumper guards.
Yeah, I think it's important to make it easier. We got to fit it to what the size of the estate and the age of the beneficiary.
That's kind of my problem with, a lot of these online services, and, I poke fun of them here and there, and there's just so many of them out there that are arising. You've got, wealth.com, you've got Guru, you've got Vanilla. And Michael, I really see a movement in this country where financial advisors are coming up with the term that advisor-led estate planning using an online estate planning platform is better than attorney-led estate planning, because attorney-led is too expensive or too time-consuming or whatever. I have a huge problem with that because, and in fact, I just wrote an article on it, that I really think estate planning needs to be driven by the lawyers. Financial planning needs to be driven by the financial planners, and people need to kind of stay in their lane. But that's where it's like, you already said it, one size doesn't fit all. And what I'm worried about, if you use these online platforms, I think you're going to get a very cookie cutter version, and you're not going to be able to consider all these factors that go into it. What other things, just quickly here, would you say, just generally speaking, people want to know what a trust costs and the estate plan costs? What would you say would be the good parameters there and ranges? And
yeah, well, just like everything else, it kind of depends on the size of the estate and the family dynamics and how we design the trust. But typically we work on flat fees here, and a flat fee includes a comprehensive estate plan: trust, will, powers of attorney, deeds for the house, funding, gives you everything. And I'd say we're typically between the $2,000 and $5,000 mark, and a lot of that depends on whether we're talking about a single person or a married couple and a family.
I think harder and harder, the $2,000 trust, you're not going to get much. It's all mathematics, right? How much can you get for $2,000? What type of an attorney is willing to spend hours and hours and hours educating you and going all these parameters. And that's where we feel like, I don't know how many times this has happened to you, Michael, but I get people come in all the time and they throw down a pile of paperwork and they say, I don't understand this at all. My attorney didn't explain anything. And I believe them. I believe that they went out looking for a $2,000 trust and they found a guy that pushed a few buttons. And I tell people, email me $100 and I'll email you a pretty dang good trust. You won't understand anything in it. You might want to do it differently, but it's not, it's not the paper. It's the magic knowing what paragraphs and what provisions. And I think another question, I hear that people ask a lot is, the basic question, do I need an attorney to do my estate plan? And I think this goes back to this attack that I'm seeing where financial advisors are saying you don't. And they're actually saying a financial advisor using a platform is better. I strongly disagree with that. And for, a lot of reasons, right? You lose attorney-client privilege. The attorneys that are behind these online platforms tend to be the younger, not as experienced and educated as maybe traditional estate planning lawyers. They just don't have enough repetition in there. But I think that, this thought, do I need an attorney? If you're going to do a trust, not only do you need an attorney, you need a very experienced, estate planning attorney, right? And I always use the analogy, legally, you don't need an attorney, but do I need a dentist to pull out this sore tooth, right? I don't need a dentist. I got a pair of pliers, and my wife's good at inflicting pain on me, and she likes me to open up and pop a pimple or something. But you don't need it, but, what are you going to get if you don't have that guidance?
Yeah, it's going to be the one-size-fits-all trust. Whether it's a financial advisor or an online service, it doesn't really matter too much what buttons you click. The trust that it spits out is going to be substantially the same. Yeah. And that just doesn't fit people, right? You need something that's going to be custom drafted to you and your family.
A lot of times we get the question of what are the 5 essential documents that we believe are very necessary in core estate planning.
Yeah, all of our trust packages, they include the 5 core documents. The first was being the trust itself. And the trust is what distributes the assets upon your passing, right? It dictates the terms of the subtrust for the kids, dictates what happens when one spouse passes away. That's the controlling document.
And the trustee of that trust dictates that, right? I always say of the fiduciaries you need to pick, I think this fiduciary being a successor trustee is one of the most important.
Absolutely. The next document you get is called a certification of trust, and that's really just a summary of the trust document that we give to banks and title companies and other financial institutions in order to properly fund the trust, to put the assets into the trust so that you get the benefit of staying out of probate.
Okay.
The third document you need is a pour-over will. So when you have a trust, you still have a will, but it's a special type of will called a pour-over will. And what that does is if you forget to put something into the trust during your lifetime, you forget to fund it, then that pour-over will is the safety net. It catches everything at your death, and it puts it into the trust when you've passed away. The fourth document you need is a durable financial power of attorney. That will cover any assets that we don't put into a trust, like a 401k or an IRA, where those still stay in your name. If you become incapacitated, your financial power of attorney can still manage and control those assets during your incapacity. And the final document is a healthcare power of attorney. Who are you going to nominate to make your healthcare decisions if you're unable to do so?
Michael, when you were talking about the pour-over will, I think one fiduciary in there that's critical, that's named in that pour-over will, that's not named in the trust, is that guardian provision. And that's something you and your wife are thinking about. Who takes care of your son if you're both gone? Who takes care of the physical needs? That's called a guardian.
Yeah.
Very, very critical. And I think for a young person like you, those are the 2 most important fiduciaries you have to think about. Who takes care of the physical needs of this son, my guardian? That's inside of the will. Who takes care of the money for the son? That's the successor trustee in the trust. Very, very critical document.
Yeah.
So, are there any other benefits of a trust you want to get into, or I hit kind of the big ones here?
Yeah, I think we've hit the big ones, other than protecting privacy, and there's creditor protection options, but again, all those options aren't available to you on an online service. You want to talk to an attorney to really get in to understand all those options.
Yeah, trusts are more private than probate, certainly. And, we haven't even talked a lot about disability. We've talked a lot about death, but if I become disabled, I'm much safer to have a trustee in play that has fiduciary duties to beneficiaries, that has duties to account to beneficiaries, handling my affairs, than somebody using a power of attorney that doesn't have accounting responsibilities and duties to the kids. I mean, I think we often overlook that, having a trust just in case, handling your affairs if you become disabled. Well, thanks for your time today, Michael, and congratulations on that baby. What did you name the baby?
His name's Callahan.
Callahan. What's the middle name?
James.
There you go. All right.
It's a mouthful.
That sounds like a very privileged kid that's coming up. So congratulations to you.
Thank you.